Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor from Faculty of Law, University of Delhi. Now coming to the two important aspects to be discussed under the doctrine of frustration, that is the grounds of doctrine of frustration or grounds of frustration of contract and certain exceptions to it. Grounds, firstly destruction of subject matter. So, I have mentioned two cases here, Taylor versus Caldwell, Howell versus Copeland. So, if I may give you example of this destruction of subject matter. So, in one of these cases, now say for example, a person is to perform in a particular theatre or has a performance to give in a particular say studio also, and before the performance could actually take place, the studio or the theatre or the premises, there is some kind of short circuit and the premises catch fire and is destroyed. So, this is what we call as destruction of subject matter, and once the subject matter gets destroyed, the party is absolved from liability because the performance is not possible now. And Howell versus Copeland, in this case, person had entered into a contract with another person wherein he was to sell his potato crop to the other person. But even before the person could he could do that, he could fulfill his obligation under the contract, the entire crop got destroyed. So, if that happens, the destruction of subject matter, it is no more performable now. Change of circumstances. A enters into a contract with B to supply rice to him. Thereafter, B's country entered into war with A's country and all the export or import transactions were stopped. Here the contract became impossible due to change of circumstance, that is, when the contract was entered into, situation was absolutely fine, but later stage before the obligation could be fulfilled, one party's country entered into war with the another party's country and all the export import transaction between these two countries was stopped. Here the contract became impossible due to change of circumstances. Next is non-occurrence of contemplated event. In Krell versus Henry, now say non-occurrence of contemplated event, if I may just explain it, say for example in this case a person had entered into a contract with another person wherein he had taken the premises of another person on rent for a particular day, because on that day procession or basically king's coronation procession was to take place, and that house of the other party was in such a was placed in such a manner, was situated in such a manner that it could give a very good view of that entire procession. But due to king's bad health, the procession got cancelled, the coronation ceremony got cancelled, which means non-occurrence of contemplated event. The event for which the premises were taken on rent, that event, contemplated event, did not occur. It was cancelled. It became impossible now. Death or incapacity of party. A pianist who had to perform at a particular concert, before the performance, say the pianist either dies or the pianist meets with an accident and is not supposed to appear for the concert, or say he or she becomes of unsound mind, right. So, that is what we call as death or incapacity of party. Further, the other grounds, if we can see, are government, legislative or administrative intervention. That means some government policy, some rules, some law has come into picture which has say which has put a prohibition on, or which has restricted or say banned a particular transaction or export import of particular goods or sale of a particular commodity, and that was the subject matter of your contract. So, if the government has put a ban or prohibition on such kind of transaction, then you cannot do that because it has become, it is a legal impossibility which has taken place. Intervention of war. Then no frustration, this is something which you need to understand, No frustration in case of executed contracts. Frustration of contract is possible only in executory contracts, that is wherein future consideration is there. It is not possible in case of those contracts wherein present consideration is involved, because we say impossibility of performance means we had entered into a contract, but before the due date of performance it has become impossible to be performed. Let us throw some light on the various exceptions to the doctrine of frustration of contract. Mere delay in performance does not amount to impossibility. Difficulty in performance is not impossibility. Mere commercial hardship is not an impossibility. So, change in economic conditions like variations in price will not affect the continuation of contract, and the parties are bound by the terms. The defendant cannot invoke or invite the doctrine of frustration by the fact of any such commercial impossibility, say low profit and stop the contract. So, this commercial hardship is not amounting to impossibility of performance. Instead, it is an exception to the doctrine of impossibility. Self-induced impossibility, we have already understood, we have already gone through it, that what self-induced impossibility is about. Now, the other two exceptions, if I may highlight: failure of one of the objects. If the contract is made to perform several objects, that is, if I have entered into a contract with you and I have hired you for performing certain categories of jobs for me, right? Not just one particular job, but certain categories of jobs I have contracted you to do for me. Made to perform several objects and one of the objects failed due to any untoward incident, the party cannot withdraw from performing the contract in toto, that is in total, as there are other objects available in the contract, right. So, failure of one of the object does not amount to impossibility, because the rest of it is performable, can be performed, still be performed. Knowledge of impossibility, now this is very important, this is also an exception to impossibility of performance. It says A, already married to a woman, promises to marry B's daughter, fully knowing that polygamy is not allowed in the country in which he resides. After marriage, B's daughter learns of this and seeks divorce, and A was sued for not disclosing this. So, he was already a married man, and without disclosing this, he promises to marry B's daughter. He is fully aware of the law of the land in which he lives, that polygamy is not allowed in the country, and after marriage, B's daughter, that is the person to whom he married for the second time, learns about this fact and she seeks divorce, and A was also sued for not disclosing this. Now, here A cannot claim the benefit of doctrine of frustration, as the contract was void ab initio, as it was illegal. Here he may note that lack of knowledge of such a law is also not an excuse for A, right. So, even if he would not have known the law and would have contracted second marriage, right, but the fact is that he did not disclose it to the other woman whom he allegedly married, and in fact we have already discussed under the session of free consent that mistake of law of Indian law, the country in which you are living, is not excusable or is not a defense.